Good evening, everybody, and welcome to the Fashion Law webinar, The Legal Issues for the Fashion Industry Today. As will be apparent to many of you, up until yesterday, we were hoping to welcome you to our offices at 10 Finsbury Square to hold an in-person seminar. Unfortunately, Omicron got in the way, and we reverted to the tried and tested Zoom method of holding this webinar. I do hope you enjoy this evening's recording and presentations by my colleagues. First up this evening will be Grace Waterhouse, who is a specialist employment law associate. Grace is going to be talking about buyer beware, what brands need to know when hiring or losing senior staff. Grace will then be handing over to my partner, Simon Bennett. Simon Bennett is one of the leading intellectual property lawyers in the country, specializing in particular in contentious issues involving soft intellectual property, trademarks, designs, the things that matter most to the fashion industry. And Simon's going to be talking about fashion and social media, what is happening and how can brands protect themselves. Simon's then going to move on and hand over to Lucy Coffey. Lucy is a specialist commercial law associate. One of the issues that is affecting the fashion industry today, not least following the COP meeting in Glasgow a few weeks ago, is the subject of greenwashing. Unfortunately, we do see fashion businesses engaging in greenwashing, and what we have now seen is the response from the Competition and Markets Authority with the introduction of a green claims code, which is due to come into force at the start of next year. But is it a case of old wine in new bottles? Lucy will be talking to us about that. And then Lucy's going to hand over to Emma Roke. Emma is one of our legal directors, another specialist in commercial law issues. And Emma's going to get out her crystal ball and do some gazing into next year, when we are expecting there to be some changes so far as the law is concerned when it comes to pricing, another issue which is very important so far as the fashion industry is concerned. There will be an opportunity at the end of this webinar for questions, and I hope my colleagues will endeavour to give answers, and insofar as I can, I will join them in that. But without further ado, I'd now like to hand over to Grace to talk about buyer beware, what brands need to know when hiring or losing senior staff. Grace, over to you.
Thanks, Steve. Yes, as Steve mentioned, my name's Grace. I'm an employment associate here at Fox Williams. And today I'm going to be talking about the movement of senior individuals within the fashion industry and how to protect your business when senior staff move on. And I've chosen to talk about this in particular because we're in a period of real movement within the industry at the moment. I've popped up on the slide there just some of the brands that have announced senior moves in the last few months. And it can be damaging for any business when an executive level employee moves on. But this is especially true in fashion businesses because you typically hold much of your value in your confidential information and in the expertise of your staff. So next slide, please, Jess. In the next 10 minutes or so, I'm just going to look at the ways in which a company can protect itself. We'll start by looking at exactly what we're aiming to protect, and then we'll turn on to the beginning of the employment relationship with recruitment and onboarding. I'm then going to talk about the various opportunities you might have during employment to strengthen those protections, and finally look at the end of the employment relationship, however that might arise, and look at what can be done then. So firstly, next slide, please, Jess. It's important to understand exactly what we're trying to safeguard against when a senior member of staff moves on. Obviously, if your creative director resigns, for example, you're going to lose expertise and experience. So we're going to want to control that process as much as possible so that the business has time to prepare and recover. We'll also be looking to mitigate against the business being tied into large payments after an employee has left. And this is typically going to be particularly relevant in the case of contentious exits, but even on amicable exits, a company is unlikely to want to pay out large bonus sums, for example. There's also reputational damage that can often arise when a senior employee announces they're moving elsewhere. And typically companies will want to control the messaging around what's happening and why. So it's important we try and retain that power at the start. Finally, and perhaps most importantly, you'll also want to ensure that your confidential information is properly protected so that you're not losing it to competitors. Now, when we talk about confidential information, there are typically three different things we might be referring to. It might be that we mean general skill and knowledge, for example, a designer's creative expertise or skill. Unfortunately, this isn't easily protectable after employment. An employee will inevitably carry this with them wherever they go. Alternatively, we might be referring to trade secrets. Now, these are commercially valuable secrets that give their owner a competitive advantage. I've popped up there. One example might be the fragrance ingredients in a perfume, or another example in fashion is the materials used to make the Nike 159 marathon shoe. Thankfully, trade secrets will automatically fall under some protection of the common law, even after the employment relationship comes to an end. But then you have that middle ground, the information that's confidential to the business, but perhaps not so obviously confidential that you'd label it a trade secret. You will know the type of information that's important to your business. It might be branding strategies or financial information, supplier lists, that kind of thing. And it's this type of confidential information that I'm really going to be focusing on here, because this won't automatically be protected unless you put proper provisions in place. Next slide, please, Jess. So with this in mind, I want to talk about the recruitment stage, because actually business protection starts before the employment relationship even begins. Most new hires at a senior level are likely to have experience within the fashion industry. They may even have come from a competitor, because it's common that people move around at the top. And what this means is that they may come with a large amount of confidential information and be subject to restrictions themselves. There's a couple of key risks to think about for businesses if this is the case. The first is that you don't want the business to be accused of inducing a breach of contract. And by that I mean accused of encouraging or allowing your new employee to breach the restrictions they have with their ex-employer by employing them when they have non-compete restrictions, for example. The second risk I've popped up on the slide there is that your company will actually be subject to common law duties of confidentiality towards that ex-employer. This is true even if the new employee doesn't explicitly tell you the information they have is confidential. And we've actually seen quite a few cases on this in the last couple of years. Now, you as a business are a far more attractive target to pursue for an ex-employer. So my tips for best practice would be, firstly, be cautious during the recruitment process. Don't ask for insider information from an interviewee or require them to disclose the new marketing strategy. Definitely don't put that as a requirement in the advert. Secondly, ask whether your incoming employee is subject to any restrictions, just so that you know what you're dealing with. They're probably required to disclose them by virtue of their employment contract anyway, but unfortunately not everyone knows their employment contract back to front. Related to this, get warranties in the contract or the offer letter. And I'm coming on to talk about the employment contract shortly. But these warranties can promise that the individual can come and work for you in the job that you've offered them on the start date that you've asked for. And that will provide you with some protection against those key risks. And my final tip on this is that a lack of encouragement to spill all their secrets isn't going to be sufficient. You should be explicitly informing new employees not to disclose confidential information from their previous employer, even where it would benefit you. Next slide, please, Jess. Thanks. So moving on to onboarding, the first place to start with any new hire is their employment contract. Now, it's really impossible to overstate the importance of the employment contract in this context. I would say that as an employment lawyer, but really it is both your sword and your shield when it comes to protecting the business. And I flagged here some of the particular points to think about when drafting the contract. Firstly, and perhaps most importantly, staying on the topic of confidential information, you'll want the employment contract to contain a bespoke confidential information clause. This is your big opportunity to prevent current employees and outgoing staff from disclosing your valuable information. And the most important thing with a confidential information clause is to make sure you properly define the information you're trying to protect. A broad limit on confidential information belonging to the business is unlikely to be enforceable. So have a think about what's valuable within your business. Some things might be obvious, new designs or a new marketing strategy, but some things might take more thought. Do you want to protect your supplier lists or what you pay your employees? Make sure they're all properly defined and covered. Some other clauses I would encourage, I also put up on the slide there. So non-derogatory clauses, in other words, clauses preventing employees from saying disparaging things about the business during and after their employment. This can be specifically extended to social media. So you really have some control over what a previous employee says on LinkedIn, for example, after they leave. I've also mentioned garden leave. It's really good to have the option to place an employee on garden leave when they're working their notice, because this allows you to keep them away from clients and suppliers if you know they're moving on. Similarly, pile-on clauses, these are fairly typical and you would see them in standard employment contracts because they allow you to terminate the employment early and pay in lieu of basic salary. But one thing we're seeing a little more of are mitigation pile-on clauses, which allow the business to pay notice in instalments and then withhold it if the employee starts in a new job. And that can help in terms of protecting ongoing departure costs. Another way to limit termination payments is by what we affectionately call the killer clause. This is a clause ensuring that if someone is working their notice, they'll lose their entitlement to receive any bonus, which can be very helpful. I've also mentioned restrictive covenants here, meaning restrictions which prevent an employee from competing, poaching your employees, or soliciting your clients. I would need a whole other session to cover restrictive covenants in detail. But I did just want to say that restrictions will only ever be enforceable if they go no further than is necessary to protect a legitimate business interest. Now, that legitimate business interest may well be your confidential information, but for example, you're unlikely to be able to enforce a 12-month non-compete against one of your admin staff who hasn't had any involvement with your confidential information. And unfortunately, the courts typically don't enforce up to where they think it would be reasonable. If it's not enforceable, they will just strike it out. So don't aim too high or too long. Just think about what you're trying to protect and what's actually necessary to achieve that. Next slide, please. Now, I'm sure some of you are probably thinking, well, that's fine, but I already have senior employees and we haven't included half of these clauses in their contracts. And that's not the end of the world, because during employment, there will be opportunities to make sure the contract's still fit for purpose. And this isn't just necessary if you think there are missing clauses. It's also the case that throughout employment, the role of an employee will change. And that means the contract they had at the beginning isn't going to be suitable in their promoted role. So what are those opportunities? Well, we're looking for points that firstly feel like a natural time to update terms and conditions, and secondly, provide some consideration to the employee. The perfect time is typically upon promotion, because employees are usually getting a salary increase at that point. Bonuses are another helpful point in the year. You might be able to take an opportunity like increasing everyone's holiday by a day and adding additional clauses or restrictions at that point. But the employment contract isn't the only way to protect the business. Policies and procedures can help too. And in particular, well-drafted policies about confidential information can help you protect not only that information during employment, but can also remind people of what your confidential information is, which helps a lot when it comes to enforcing it afterwards. I've mentioned training there, and that's because policies are really only useful when they're followed. So invest in training to remind people of their obligations and to ensure there aren't any mistakes. Next slide, please, Jess. I'm just going to talk briefly about the end of employment. If I can go on to the next slide, Jess. Thank you. Now, there are various ways in which the end of employment might come about. Perhaps the employee resigns, perhaps there's some contentious aspect to it. But whatever the case, there are some key things to be aware of. Firstly, the exit letter. This is a letter that most businesses will send when someone resigns. And it will just be an admin exercise, confirming the arrangements for their departure, their last day, what to do with their laptop, that kind of thing. But rather than it simply being an admin exercise, you can use the exit letter to strengthen your current protections. For example, if they are subject to restrictive covenants, as senior execs may well be, restate them in the exit letter and ask the employee to sign an undertaking that they agree to them. Remind the employee of their confidentiality obligations and ensure they understand what this means practically. Explain how you want to manage the exit and who the employee should talk to or not talk to about their departure. You'll also want to think about the arrangements you want to put in place during an employee's notice period. Do you need to keep them away from clients and other employees, for example? If so, perhaps you may want to put them on garden leave if you have the right to do so, or pay them in lieu of notice. Could you vary their duties slightly to keep them in a less client-facing role, or to keep them away from newer designs or strategies? Remember, if you do vary their duties, you need to have the right to do so. And whatever you ask them to do should be consistent with the status of their current employment. I've asked, will a settlement agreement be appropriate? Now, this is something we typically see used in contentious situations, but there's nothing to prevent you from using them in any situation, even an amicable one, if you want a little more control over the exit and can offer the employee something beneficial in return. Just remember though, with settlement agreements, an individual has to take independent legal advice, which, though I hate to say it, will potentially complicate matters if the lawyer raises irritating questions. Finally, what if it goes wrong? And by this I mean, what if your employee walks out, runs to a competitor and starts spilling all of your confidential information? There are things that can be done in these situations, but you just need to act quickly because any legal action loses its power if you take too long. So my suggestion is gather evidence of wrongdoing and then seek legal advice as early as possible. Next slide, please, Jess. So these are my 5 top tips, just to summarize. Firstly, check a new hire's existing restrictions and discourage them from sharing confidential information. Ensure the employment contract includes all those comprehensive business protection clauses that I mentioned at the beginning. Consider the types of confidential information within the business and tailor the clause to make sure it really covers that information. Use the opportunities you have during employment, such as promotions and bonuses, to revisit those contracts and bolster any restrictive covenants. And finally, make the most of the exit letter. Don't let it be just an admin exercise, but reinforce the restrictions and confidentiality obligations. I now believe I'm handing over to Simon Bennett, who's covering what's happening in terms of social media for fashion businesses. If you do have any questions in relation to anything I've mentioned, do pop them in the Q&A box and I'll do my best to answer them at the end.
Thank you very much, Grace. Next slide. Thank you, Jess. So yeah, I'm going to be talking about some brand protection issues on social media, and also some regulatory aspects of social media as well, which I'll come on to later. Let's start with brand protection. First issue is the issue of counterfeits, fake accounts, copied postings, and fake reviews. How do you stop that? Well, we do a lot of takedown requests here at Fox Williams, and one of the things that we find most most helpful when submitting a takedown request is having a trademark to protect your brand. If you don't have that, it becomes a lot more difficult to police social media. As you know, a lot of people see social media as a free-for-all. They think that there's no rights there to protect, and anyone can use anyone's brand with impunity. That's not the case. But to have the ability to take down counterfeit goods or fake accounts, it is very important that you have a trademark. So that's my key message for that for takedown requests. Next slide, please, Jess. One thing you have to be careful though with when you do takedown requests is, and we've had this before with some clients, not all things that are being resold online are in fact counterfeits. Some are in fact resales of genuine goods, or they could be even sales made by distributors that have authorizations to sell the items. And so care does have to be taken before submitting a takedown request, because if you do submit a takedown request and it turns out that the goods are not counterfeit and they are legitimate goods, that could get you into hot water. So note of caution there. Next slide, please, Jess. Another aspect, another sort of way of protecting, and I think Steve mentioned when he introduced me that we do a lot of design protection here at Fox Williams. So we protect fashion designs in particular. One way, another way of sort of protecting yourselves on social media is to register your clothing designs. That's very important. Again, if you're submitting a takedown request, having a registration certificate that you can attach to that takedown request, showing that you have rights to that design, is very, very powerful. And it is a lot more powerful than trying to construct a case of how you designed the item, showing the drawings that you made, and all of that sort of evidence that you need to corral together if you were going to do it based on an unregistered design. Registered designs are very easy to register in the UK and in the EU for that matter, and it is particularly for important designs something that you should register very, you should take very seriously, and register early as well, because as soon as you release that design, and particularly if it's being worn by a celebrity, as is seen by the pictures on the slide, it soon is copied. In fact, there have been the apocryphal story of even the time it takes to walk down the catwalk. A copy can be made and will be in the stores within the week. So register before you exhibit on the catwalk, and register early. Next slide, please, Jess. So another thing with social media that you've got to be a little bit more careful of is image rights. And some of you will be aware of this particular incident, or this case that happened a few years ago involving Rihanna and Topshop. In fact, Topshop, to give them their credit, thought they'd done everything right in this case, because they had secured a license to the photograph, the copyright in the photograph that's on this T-shirt. They thought that they thought they'd done their homework, checked, got the copyright license for the photograph, and then put it on the T-shirt. But in fact, what they hadn't done is got permission from Rihanna herself to use her image. And in this context, that was a big mistake, because Rihanna was known for endorsing clothing and had previously a deal with River Island to have her likeness on their clothing. And although this picture is in fact one of her album covers, the court held, and this went to the highest court in the land, in the UK, the court held that this was an infringement of her image rights, to use the layperson's term, and was unlawful, and as a result awarded big damages. So that is a lesson on how you have to be careful when using images and copyright material in particular, when you're advertising your products, in particular when you're using the images of famous people as well. So a note of caution there. Next slide, please. So turning to social media advertising, this has become a very hot topic, particularly recently, particularly with Instagram and celebrities, well-known people using Instagram prolifically, and also benefiting from advertising products, and particularly fashion products on Instagram. And the issue, as everybody is probably aware on this, the issue is what is a paid for endorsement and what isn't. And I think I'm going to be coming on to the ASA guide for influencers in a minute, but I mean that is the body, though, the ASA, the Advertising Standards Authority, which regulates the use of this type of activity online. And I suppose there's some takeaway messages to make sure you fall within those guidelines. Essentially, those are that if you include prices, you have to make sure that they clearly state that the data is accurate. If you promise availability, you have to make sure that remains the case. You have to make sure if you have a link, it goes to the right landing page. If a celebrity is endorsing an item, it has to clearly state that with the hashtag ad on the face of it. And if you retweet or share user comments, even then you might find that you're governed by the ASA CAP code. So those same rules apply even if you're just retweeting or commenting. So next slide, please. So this is the ASA guide for influencers. So I'd recommend anyone who is using influencers or to advertise their products, it looks at this and familiarizes themselves with it, because this is important when it comes to making sure you don't fall foul of the rules. And if I go on to the next slide, you'll see why. This is a recent case involving Gabby Allen of Love Island, when she was advertising Primark, some Primark jeans, I think they were, on Instagram. She didn't make it clear on her page that that she was working with Primark on, and she was advertising Primark products, even though she was using the hashtag work for Primark. So the Advertising Standards Authority took a very dim view and said it wasn't clear enough, even though she had that hashtag. They stated that she should have followed the code, which says you have to make it much clearer, and you have to have the hashtag ad on there. And this, even though as soon as the complaint was made, she did put that up there, the ASA still said that she'd fallen foul of the rules. And crucially as well, so had Primark. So it's not just the influencer that can be admonished in these sorts of situations, it's also the retailer as well. And in that case, Primark had a, and this was only last month, by the way. And as you can see from the list on the slides there, there's a whole load of people who've had fallen foul of the rules. And in fact, that list is a lot longer than that. If you went through all the way through to the beginning of the year, so it is you have to be very careful, and you have to follow the rules, and make sure that you make it clear to consumers that this is paid for content. So next slide, please. Just another comment really on hashtags and trademarks really. It is possible to register a trademark as a hashtag in your brand, and some brands have done this, including Lululemon. Stefanel have also done it as well. And also if you have a slogan, you might want to try and do that as well, although slogans are quite difficult to protect as trademarks. But again, that's been done by brands. And why have they done that? Well, they've done that to try and make sure that somebody else doesn't steal their brand and use it, and it makes it easier to take down material where somebody's trying to imitate the brand or copy them. So that's why it's worthwhile trying to register them as trademarks. Although a note of caution on that, if you are going to register them as trademarks, you should be using them, because if you don't use a trademark for a period of 5 years, that trademark is vulnerable to be cancelled for non-use. So that's you have to bear that in mind if you are going to register your hashtag as a trademark. The final point, if we go to the next slide, final point is, so I've just do a bit of horizon scanning here. There's a new consultation that's come out from the ASA, which closes in January, in fact, and that is a consultation paper on ads regarding body image and ads that might have a harmful impact on body image. And this goes to the issue that where some overly skinny models are used, or I suppose it's trying to regulate the way ads are used, and what consumers' perceptions are of body images as well. So it's worth having a look at that if you're interested, because that's probably coming down the track. And since it's a consultation, if you have views on it, I'm sure the ASA would be pleased to hear from you. And that's open until January 2022, and that's next January. And if you just Google ASA consultation body image, you'll find it. That's something coming down the line, and once that consultation's finalised, I think you can probably expect some additional rules coming out of the ASA on how body image is dealt with online and on social media. So something to think about. And thanks very much for listening. And now I will hand you over to Lucy.
Thanks very much, Simon. Today I'm going to speak to you about greenwashing and why fashion businesses need to be wary of the Green Claims Code, which was launched by the Competition and Markets Authority towards the end of September this year. Next slide, please, Jess. I'll start today's talk by sharing with you some words and phrases that are often used by fashion brands when making green claims. However, the issue is that they use these words and phrases without having the proof to validate the claim, and that's greenwashing. For today's consumer, whether or not a product is eco-friendly or sustainable is really important. And it's clear that fashion brands are listening. So recently we saw Chloe reach B Corp status as the first luxury brand to do so. And the reason why fashion brands are listening and taking these steps is because of the impact that the industry has on the environment. A recent Times article suggests that fashion is responsible for 1/10 of global carbon emissions. The combination of consumers focusing on green products and the negative reputation of the fashion industry in respect of its environmental impact means that fashion brands are keen to advertise their green credentials. However, in a rush to attempt to tick the green box, certain brands are claiming green claims without having the evidence to back them up. And greenwashing by some is causing there to be a doubt generally throughout the industry in terms of green claims being made. The Competition and Markets Authority, the CMA, estimates that about 40% of green claims could be misleading consumers. That isn't limited to fashion, it is across the board. However, by launching the Green Claims Code, the idea is to rebuild the trust in green claims. This will help in turn businesses that make legitimate green claims benefit from doing so, and the hope is that will then encourage others to be more green. Jess, next slide, please. So what is a green claim? It's an environmental claim made in respect of a product at any stage of its life cycle or services that are put onto the market by a business. The claims can be made by any business in the supply chain. So you're talking your manufacturer, your distributor, your retailer, and even your platform. And the objective is to advertise the eco benefits of your product or your service over above other products and services on the market. The words and phrases used in my first slide are often used as green claims for branded products. And as with any claim made by a business to a consumer or another business, that claim cannot be misleading. This is a fundamental part of consumer protection law in respect of making claims towards consumers. It's not limited to green claims, and it's not new law. Next slide, please, Jess. So what is a misleading claim? So under consumer protection legislation, there are 3 areas of concern in respect of making green claims. The first is banned practices. So this might be where you display a quality mark, but you don't have the approval to do so. The second is misleading acts and omissions. So things you're saying, things that you're not saying. And the third is unfair practices. And this is where the business does something against standards that it should be achieving. And that has an effect on a consumer's economic behavior. In terms of misleading claims, it's not necessary for the claim to lead to a purchase. It's enough if the misleading claim causes there to be an effect on the consumer's decision-making process. Whether a claim is misleading, therefore, has a low threshold. It's important to remember that what's being said and what isn't being said is equally important. And if you do mislead consumers, you can face action from the CMA, trading standards, the Advertising Standards Authority, as Simon just mentioned, and consumers themselves. And that action isn't limited to just civil action, but can also lead to criminal enforcement where you infringe consumer protection legislation. Next slide, please, Jess. Whilst the law that governs the area isn't new, as I said, the CMA considers that given the vast volume of misleading or potentially misleading claims on the market, it's important to introduce fresh guidance in the area. And that's where the Green Claims Code comes in. It's a code that aims to help businesses operating throughout the supply chain understand their obligations when making environmental claims. It is a code, and it's therefore not law and it's not binding. But as I said, it is based on existing law. The consequence of that is that there's no implementation period, so no time to get up to scratch. This is something you should be doing already. The code is based on 6 principles, and the CMA/government have launched some helpful guidance, which is aimed to help businesses visualize potential issues and understand legal obligations and how those work in practice. I'll take you through the principles and a couple of those examples as follows. So firstly, claims must be truthful and accurate. So claims are to only include information that's correct and true. So by way of example, if you want to claim that your product's organic, but it's actually only organic in respect of certain materials used, if you were to say that the product's organic, you're potentially misleading consumers and you need to caveat your claim. That caveat has to be clear to the consumer. The second principle is that claims must be clear and unambiguous. So an example given by the guidance is where you say your product's recyclable, but you don't say whether that's in whole or in part, or perhaps just in respect of outer packaging. The third principle is that claims must not omit or hide relevant, important information. So information may be relevant where you're giving an overall impression that your products meet certain environmental standards, but the claim should be in respect of a particular part or process of that product. You have to be careful with what you're saying, the images you're using, and even the colors. So the fourth principle is comparisons must be fair and meaningful. You must make sure that the products are comparable. You're comparing like with like. So perhaps you want to say that your product is greener than other products in the market. You need to be clear what that other group of products are. And you should avoid saying things like greener or more sustainable and stick to facts and figures. The fifth principle is that claims must be substantiated. So ignoring things like mere advertising puff, you do need to be able to back up your environmental claims. Ask yourself, is the evidence based on scientific fact, accepted understanding, or is it just untested? The consumers, the CMA, and the other authorities I mentioned earlier will want to be able to check on the basis of your claim and verify that it's true and accurate. Claims must consider the full life cycle of the product or service, and that's the sixth and final principle. So broad claims here are going to cause you more of a headache. If you can be specific in respect of what you're claiming, then you're less likely to be in a position where you're having to face claims of misleading consumers. By way of example, if you say that your product is now 33% more eco-friendly because your outer packaging is recyclable, but the only way that you got the outer packaging to be recyclable was to move factories, and that factory is now further away, so your environmental impact's actually increased. So your claim may be misleading if you weren't to caveat or provide further information to consumers in respect of that claim. As I'm sure you'll recognize, the principles and the examples, they do overlap. However, each serve as a useful reminder when you're looking to make green claims, but also when you're undertaking due diligence. It's really important to be looking at what you're already saying. And the reason for that is because the CMA has already said that come January, it will be focused on green claims. And we all know that retail is an area of concern in respect to greenwashing. Thanks, Jess. Next slide, please. So I thought I'd end today with my talk in terms of some good green news. So how are fashion businesses looking to maximize on green claims? Brands that are leading the way in terms of ensuring green claims are standing out from this backdrop of greenwashing are doing so in innovative ways. The first topic is the use of QR codes for labels. So one issue, as we all know, is that brands can face a problem in terms of the labeling space when wanting to make green claims and at the same time sufficiently providing information to consumers so as to avoid being misleading. You'll have no doubt seen certain high street brands which use broad brush terms on their labels in terms of their environmental green claims, but there's no further information provided. So at best, it's confusing, if not misleading. One suggestion by the CMA is the use of QR codes on the product labels, so consumers can scan the QR codes and find further information in respect to that product. Certain luxury brands, such as Mulberry, Stella McCartney, and Johnson's of Albion, are reported to have teamed up with a tech company so as to provide QR codes on their labels for autumn-winter 22 products. The consumer will be able to scan the QR code and find a digital birth certificate so as to provide further information in terms of origin of that product. The second hot topic is B Corp certification. So obtaining B Corp certification is no easy feat. It's a certification awarded to businesses that balance profit and purpose, and those businesses that seek out sustainable practices in respect of their supply chains and their wider network. A report by PwC considers that obtaining or achieving B Corp certification has the obvious advantages in respect of impact on brand equity, attracting talent, but it also can improve scalability of a business and lead to increased growth. Whether B Corp certification is achieved is based on answers to 200 questions, and those questions focus on governance, community, workers, the environment, and customers. In a crowded marketplace, particularly with all this greenwashing in the retail space, B Corp certification is for some brands a way of standing out. And as I mentioned, Chloe has achieved B Corp certification. We know of Patagonia, Faithful the brand, and the platform Vestia Collective. The third interesting development is that of digital supply chain mapping. Certain brands have been signing up to platforms to, if you'll allow me, track, trace, and report on supply chain routes, and in turn provide information in respect of the environmental impact of the brand. The idea is to be transparent with the industry and the consumer, but at the same time provide a monitoring tool for the brand and its stakeholders. The aim is to reduce the risk of there being an unknown party in the supply chain that's acting in a way contrary to the law or even the accepted ESG principles of the brand. And that brings me to the fourth topic, ESG policies. ESG policies are on the up, either because brands are expecting more from supply partners or because retail customers are demanding them. In acting for fashion brands recently, we've seen two approaches being made to ESG policies. The first is detailed specific obligations that are placed on the partner and they have to achieve those obligations. And the second is more overarching principle-based ESG policies where the kind of principles of what the partner should strive to achieve. Each has their uses, and often environmental impact will be something that plays a part in terms of putting together an ESG policy. However, the first type of policy will have more teeth if something were to go wrong. On the flip side, of course, it can prevent the brand partner from wanting to sign up and be part of your supply chain in the first place, however, if the obligations are too strict, for example. I anticipate looking forward, the majority of businesses, particularly fashion businesses, will put in place ESG policies where they haven't done so already. And that's because they provide a useful statement to third parties, including your consumer, on the environmental, social, and governance values of the brand. Is this something you're doing? Is this something you're looking to do in the near future? And with that, I will hand over to Emma, who's going to discuss pricing.
Thanks, Lucy. This evening, I'm going to be discussing how EU and UK competition law is being overhauled in 2022. There are some changes coming down the line in relation to prices. Next slide, please, Jess. But spoiler alert, price fixing and resale price maintenance are and will continue to be hardcore restrictions of competition law and against the law. Just ask these organisations, Rangers Football Club, JD Sports and Leicester City Football Club. In the last year, the UK's competition law regulator, the CMA, has opened up 2 investigations into resale price maintenance in the replica football kits market. One in relation to Rangers, another in relation to Leicester City Football Club, and both involving JD Sports, who appears to be going for something of a competition law hat-trick this year with a recent finding of the CMA in relation to the takeover of Foot Asylum. So price fixing, resale price maintenance is still very much a hot topic for the UK's competition law regulator. Next slide, please, Jess. So in this talk, we're going to look at the rules relating to pricing, because many of them won't actually be changing that much. And these are things that everyone in the fashion industry needs to know about. And also we'll look at the end at how things might change in 2022. So first of all, the fundamentals. A fashion brand that doesn't hold a dominant position in the market for the types of products which it sells, for someone who isn't a Nike, for example, has considerable freedom as to the prices at which it sells its products to its direct customers. So the brand can generally charge whatever its direct customers will pay. It can discriminate between its customers. It can refuse to supply anyone who won't pay its prices. So long as it sets its prices and discounts according to its own policies and not in coordination with its competitors, it will generally be free from attack from competition or regulators, with the sole proviso that the fashion brand must not impose minimum resale prices on its customers. Next slide, please, Jess. So we've all heard of price fixing, and most brands know that fixing the prices at which distributors or retailers can resell your products is against the law. But what's not always appreciated by brands is that there are various pricing practices, short of actually agreeing with your distributors or retailers what exactly the fixed resale price of a product will be, which could get you into hot water. And these other pricing practices are usually called indirect resale price maintenance. It's a bit of a mouthful. But in the context of relationships between fashion brands and their distributors and retailers, resale price maintenance generally refers to any steps which are taken which are designed to ensure that the distributors or retailers or both do not sell the brand's products for less than a minimum resale price. Competition law prohibits resale price maintenance because in general, it leads to consumers paying higher prices. It's as simple as that. So some examples of indirect resale price maintenance are as follows. So if the supplier fixes a distributor's distribution margin, if the brand fixes a maximum level of discount which the distributor can grant to retailers from a specified price level, when the supplier links the specified resale price to the resale prices of competitors, and finally, threats, intimidation, warnings, penalties, delay or suspension of deliveries or contract terminations by the brand if a distributor or retailer fails to observe or enforce a particular price. So where do RRPs come into all this? Well, setting recommended retail prices isn't against the law unless the RRPs are accompanied by other restrictions or inducements which have the effect of making the RRPs a minimum resale price in all but name. And a good example of this is the ultra bathroom fittings case, in which the CMA, the UK's competition regulator, found that a recommendation given by ultra bathrooms to resellers regarding prices had in practice restricted the ability of those resellers to set online prices below the recommended level, as the RRP was supported by various monitoring and enforcement mechanisms. So what happened in this case? Well, it started, as it usually does, with a number of Ultra's brick and mortar resellers complaining to Ultra that there'd been significant discounting of Ultra's products online. And in response to this, Ultra introduced an online trading policy. And that policy required Ultra's resellers not to resell its products online below a maximum discount of 20% off the RRP. And there were consequences for failing to comply with the maximum discount, including reducing resellers' wholesale terms and also withdrawal of Ultra's permission to the reseller to use Ultra's copyrighted images on resellers' websites. You can imagine it's quite onerous. A few years later, Ultra must have got wind that it was maybe running a bit of a risk with this policy. So it revised it so that the policy contained a recommendation which was expressly stated to be not legally binding, that online prices should be no lower than 25% off in-store RRPs for Ultra's products. However, despite being described as a non-binding recommendation, the evidence showed that Ultra aimed to prevent resellers from selling or advertising its products online below a specified level. And also, at least some of Ultra's resellers understood the guidelines required them to price at or above the recommended online price. In addition to that, Ultra regularly monitored resellers' websites to check that resellers were not selling or advertising its products below the recommended price. It threatened or took enforcement action if it found they were. So it temporarily or permanently ceased supply. It reduced wholesale terms of supply. And it withdrew various resellers' rights to use the images of Ultra's products. And Ultra was fined by the UK's competition law regulator for this. Next slide, please, Jess. So Resale price maintenance is against the law, and the consequences of engaging in it can be very severe. So fines can be as much as 10% of the business's worldwide turnover. And competition law regulators in the UK and across the EU are increasingly active in their investigation and prosecution of resale price maintenance, particularly in relation to the online channel. And as an example of this, in the last 2 years, the CMA, the UK's competition law regulator, has heavily pursued suppliers and retailers in the musical instruments industry in 5 investigations into resale price maintenance, which led to the CMA imposing fines totaling 13.7 million and sending a warning letter to the whole industry. And the problem was so bad in this industry that on the back of it, the CMA has developed its own price monitoring software, which it uses to detect resale price maintenance in the musical industry sector. But it also will be rolling out to use against other sectors which it considers to be sectors of concern. I've mentioned price monitoring software on the slides. In recent years, the CMA and other national competition law regulators in the EU have been heavily critical of parties which use software to detect and punish resellers who sell below their RRPs. So whilst it's not illegal to use online price monitoring software, you should be very, very careful if you do so, because the fact of your using it might lead to increased scrutiny from competition law regulators if you were to come under investigation. Finally, it's not just suppliers that can be fined. Distributors and retailers, which are active participants in resale price maintenance, have also been fined. And there was, in one of the cases in musical instruments investigation, there was a retailer who was shopping other retailers who were selling below the RRP, who did receive a fine for that active involvement. And in addition, the CMA has mentioned in a recent blog that it's considering using its powers in order to pursue directed disqualifications in resale price maintenance cases. Usually a competition regulator like the CMA would only do that if there was cartel type behaviour, but now it is considering extending those pursuing directors whose organisations have engaged in resale price maintenance cases. And next slide, please, Jess. So after that browbeating, is there anything to be hopeful of in terms of the likely changes in 2022? Well, nothing's yet confirmed, but it looks as though dual pricing will no longer be a hardcore breach of competition law. So what's dual pricing? Well, that's where a brand charges the same reseller a higher price for products which are intended to be resold online than for products intending to be resold offline. And this does allow fashion brands to incentivize hybrid resellers to invest in brick and mortar retail. Finally, there are very limited exceptions where resale price maintenance can be justified. They are so limited and so precarious to engage in that most suppliers don't go near it because of the risk of getting it wrong is so severe. But the CMA in its consultation has come under a lot of pressure from stakeholders to give more guidance on where resale price maintenance could potentially be justified. You need to show that there were efficiency. You need to show an efficiency justification to justify the use of resale price maintenance. As I say, the actual exceptions to the general rule are very, very narrow, but the CMA has reiterated that it will give more guidance in the coming weeks and months, and hopefully that will provide some clarity for fashion brands going forward. Thank you very much. I'll now hand back to Steve for Q&A.
Emma, thank you very much indeed. And at this time, we do have some questions which we will endeavour to answer. But if anybody wants to put a question to us, please fill it into the Q&A box which you have access to. So let me start with some of the questions which have been received. I think, Grace, there's one for you. One of our viewers has drawn attention to Marco Gobbetti, who's worked as CEO for Celine and Burberry and will shortly be acting for Ferragamo. Appreciating that the employment contracts in question, 2 of them may well have been written under a non-English law. So let's just put that to one side. Burberry almost certainly was written under English law. If they had been written, all of them, under English law, do you think he would have signed a non-compete, or do you think he might have said, I'm Marco Gobbetti, I don't enter into non-compete restrictions. Any thoughts, Grace?
Yeah, thanks, Steve. I think it's always interesting when you see people at the top jumping ship and thinking about exactly what has gone on behind the scenes. I mean, it may well be that he's negotiated something when joining. Big names often have a lot more negotiating power. I mean, non-competes are fairly common even within the fashion industry. And actually, I think you mentioned Burberry. Burberry had quite a lot of difficulty recruiting its chief creative officer a couple of years ago because of the non-competes of its prime candidates. So they are fairly common, but they are the hardest to enforce. So typically they are the ones that people try and negotiate out of. And often it's easier when people move on to agree these things in advance. So they may well have come to some kind of arrangement if he was moving on.
Okay, thank you very much for that, Grace. Moving on from that, Simon, you referenced the Advertising Standards Authority. A question has been asked by one of the viewers of our webinar as to whether this only has applicability, or whether the ASA only has applicability for the UK, or does it have what might be described as international application? Simon, over to you.
Thank you very much, and thanks very much for the question. Well, the ASA is a UK body, and it primarily regulates UK issues, including so that will apply to, in fact, any social media or any online advertising that is directed at the UK. When it doesn't regulate directly the USA. I think if you're looking at regulation in the USA, that's probably regulated by the Federal Trade Commission, the FTC, because that's the body in the USA that regulates advertising, and I believe it also regulates what influencers do. And so you'd need to have a look at that for regulation in the USA directly. But I think, like anything, and particularly with social media, if you're directing even if you're based in the US, if you're directing your advertising over to the UK, then you should have regard for the ASA code.
Simon, thank you very much indeed, and spot on so far as the application of the Federal Trade Commission in the United States. A couple of years ago, it did write some very pointed letters to a number of influencers and wannabe influencers, asking them why it was that they were doing what they were doing and not making clear that they were getting paid for it. Some very pointed communications flowed from that. Let's turn to the subject of greenwashing. A question has been asked whether the Green Claims Code is again going to be only applicable to the UK, or does it have a greater geographical reach? Lucy, any thoughts on that?
Thanks, Steve, and thanks so much for the question. I can see that there's a question in terms of applicability, to USA and Canada, and also kind of what's happening in the EU there. As Simon said, in respect to the ASA, the CMA is concentrated on what's happening here in the UK. But taking the example of competition law, for example, it is the case that both the ASA and the CMA are working within broader networks. So it's not just limited to what's going on here that's on their radar or what's on the radar of their equivalents elsewhere. What's important to understand is that the legislation that underpins the Green Claims Code is legislation here in the UK, but it's based off EU legislation. So the idea of not misleading consumers is applicable not just here in the UK, but in a broader European basis. I know that in terms of, for example, local legislation, France has been putting in place or attempting to put in place some legislation dealing with greenwashing. And I think it will be a bit of a case of watch what happens next and see whether there'll be more teeth given to countries, including the UK, as to what happens where claims are misleading in the kind of green sphere.
Thank you, Lucy. I'm confident that we will see more teeth introduced as time passes. And I would also draw everyone's attention to the fact that in certain member states of the European Union, there exist consumer bodies which are not state bodies. These are what we might describe as NGOs, which have taken it upon themselves to enforce local law requirements. So be aware of that. These are quite powerful bodies, and you certainly do not want to get on the wrong side of them, as one of our fashion clients unfortunately found itself. Emma, we've had a couple of questions in concerning discounting, or more particularly no discounting. One of our viewers has drawn attention to Montclair. There's apparently been a threat of having the brand pulled from the discounting wholesale client. From what you said, this is not allowed?
No. I mean, I don't know the precise details, but basically prohibiting discounts going to fall foul of the rules on resale price maintenance. I think sometimes brands can, to an extent, say when seasonal products can go on sale, but I think they have to be generally quite careful. I know it certainly used to be the case that there were certain sale periods that brands used to set, but I'm not sure whether they are still, whether people still engage in that.
Indeed, although for some brands that are having a hard time of it in today's market, they could be said to be constantly, if not on sale, then certainly on promotion, and it's difficult to pick the time when they're not on promotion. Simon, if I may, back to you. There's been a question about a particular business that bought or set up a UK website and Instagram account containing the brand name, and this was done with the agreement of the brand. Who has control of the website? Who has control of the Instagram account as and when the relationship with the brand comes to an end? And as an attempt to do two birds with one stone, so to speak, what's the position of an EU trademark in the UK and vice versa, which I think has something to do with the subject of Brexit? Simon, any thoughts?
Yeah, well, to answer the last question first, yeah, as you've correctly identified, because of Brexit, EU trademarks no longer cover the UK. So if you want protection of your brand in the UK, an EU trademark will not give you that protection. So you will need to have a UK trademark to protect your brand in the UK. And similarly, if you want to protect your brand in the EU or member states of the EU as currently formed, you will need an EU trademark. In respect of the website question, if you as a distributor, if you end your agreement with the brand, I would imagine that the supply agreement has some sort of clause in it that states what you should and shouldn't do with the brand when the supply agreement ends. If it doesn't, then it falls back onto the rights of the trademark rights of the owner, in fact. So the brand owner, if it owns a trademark for the brand, has rights to that name. This means that it can ask for the it could potentially ask for the Instagram account or the website name to be transferred to it, possibly, or taken down. I'd have to see it in a bit more detail to give you a more definite answer. But you would not necessarily, you probably wouldn't have the rights to the name once the supply agreement is finished. And although the website and Instagram, you will technically own that because you've registered it, it is open for the brand owner potentially to try and take that off you if it wants to. But I'm more than happy to talk to you offline about that, because that's a very simple answer to what could be a complex scenario.
I'm muted, sorry about that. And thank you, Simon. Just a couple more questions before we close. So question has been asked about posting of images of press articles that feature the brand, and does that put the brand at risk of being told that it's got to pay what are called backdated copyright fees? So that's one further question for you. And a more open question, do influencers have to disclose they are advertising if it's their own brand, or if they've been sent products without any monetary incentive to show the products? Simon, over to you again.
Okay, thank you very much. So on the copyright point, short answer is in most cases probably yes. If you post an image of a press article, that could well be copyright infringement in the press article. The newspaper licensing agency regulates the copying and posting of newspaper articles. So you are likely to get maybe something from them if you start posting press articles. And if that press article has a photograph in it, you may also get a notice from the photographer or the society that represents the photographer in respect of copyright. So I'd be a little bit careful of that. So on the copyright front. On the ASA influencers issue, just because you are, if you happen to be an influencer and you happen to own the brand as well, generally speaking, you still would have to, you still have to say if it's an ad, even if it's your own product. And that also goes for if you're advertising a product but you're not giving any monetary incentive, because if you've been sent them for free, there is still some benefit you're getting from that because you've got them for free effectively. So although you're not being paid for that, you are getting that benefit of free clothing.
Simon, thank you very much indeed. I'm conscious that time is moving on and that we have actually reached the end of our allotted slot. For more information, please do visit our website, fashionlaw.co.uk. I hope that everyone has enjoyed this evening's webinar. I would like to say thank you to Simon and Grace and Lucy and Emma for their presentations, and for being prepared to be put on the spot and answer the questions which have followed. If there are further questions, please feel free to put in emails, or I think there is a contact service through the fashionlaw.co.uk website. But if you do put in your questions or contact us, we will certainly endeavour to answer the questions which we are received. And with that, I would like to draw this webinar to a close. Thank you very much for joining us this evening, and I wish everyone a safe and well evening. And please, given everything else that is going on at the moment in the UK, please do take care. Thank you and good evening.